This is William and Lonsdale, a podcast about the legal ecosystem and the fascinating people who make it tick. Today, your host Michael Green speaks with lawyer Michael Kingston. Michael has had a diverse and fascinating career. Beginning with articles at Mallesons, he went on to become a partner and spend over 2 decades working there, with secondments at BHP, in London and in Papua New Guinea along the way. He went to the bar for a few years, but ultimately decided it wasn't for him, and instead became the Chief Legal Officer at ASIC, the Australian Securities and Investments Commission, and most recently acted as the Australian Government Solicitor for 7 years. But like many, in the early days of his career, Michael had a dash of imposter syndrome when advising clients, and never more so than when he went to London to work at the esteemed UK law firm Slaughter and Main. But, much to his surprise, his expectations were turned on their head.
But I had expected probably Slaughter and Main to be at least as formal, if not more formal, than Mallesons. And bear in mind, we are talking 1986. But in fact, it was less formal than the Australian firms. The supervision was a bit more hands-off. The attitude of the partners was more to sort of give you a head and see how you went. And there was less talk about billing targets. In fact, in my 2 years there, I was never told if I had a budget and what it was. You just were expected to do the work, and then at the end of it, it was billed. There was no interim billing as the matter ran. You just billed at the end. They were a firm that was very confident about their place in the legal marketplace, and I think that contributed to this more relaxed attitude about some things. I was a bit surprised clients accepted this, especially in my early days, this sort of lawyer just off the boat from Australia turning up on their own to advise them on English law. But I think in retrospect, it's because you wore the brand of the firm on your forehead sort of thing, and they were trusting the firm, not you individually.
Our guest this morning in Lives in the Law is Michael Kingston. Michael's had a very varied life in the law and very interesting life in the law. And in his latest incarnation in the law, he was the Australian Government Solicitor. Michael, welcome and good morning.
Good morning. Thanks for having me along.
So, Michael, let's get back to the start. You grew up in the eastern suburbs of Melbourne?
I'm just trying to think whether they'd be called the eastern. Initially in Fairfield, which is probably more very inner north, and then Lower Templestowe, which is eastern suburbs, yeah.
Well, tell us about your time then, your schooling and things like that.
Okay. Well, I think it was pretty unremarkable in the scheme of things. I enjoyed school, both at primary and secondary level. When it came to secondary school, I'd applied to get a scholarship at Ivanhoe Grammar School, and I succeeded in getting what was called a half scholarship, which means that the school covers half the fees and your parents are responsible for the other half. And my mother sort of accepted what was for her a considerable burden of paying those fees. And that lasted for a few years until the school ended up giving me a full scholarship a bit down the track. So that was her sacrifice to send me to Ivanhoe, where I really enjoyed my time. I was fortunate because not everyone enjoys school, obviously, but I enjoyed the academic side and I also enjoyed the other activities you could get up to at school.
Michael, among the other activities were cadets.
Yes.
Now, cadets were commonplace then, but I don't think they exist anymore.
I'm not sure. There might be the odd sort of independent school which runs some sort of quasi-cadet program, but yeah, they're not common.
Well, tell us about cadets. What did you do in cadets and were they a valuable part of your schooling, education?
Yes. Well, cadets were compulsory at Year 9 and I really didn't want to go into them, and for years 10 and 11, you then had a choice. You could do cadets or community service. And I thought, well, I'm definitely going to do community service by the time I get to Year 10. But in fact, I ended up staying cadets years 9, 10, 11 and 12, where you didn't actually have to do anything because I ended up enjoying it. Partly, I think there were 2 camps during the year, which I enjoyed. And also after the first year, you specialised in something. It might have been communications or sort of the infrastructure around going out on camps and creating.
So when you say camps,
yep.
One would be at Puckapunyal, the army camp near Seymour.
I did end up going to Puckapunyal, but it was more you went into sort of state forests, where there simply wasn't any existing infrastructure and you had to, as well as having tents, you created showers and latrines and places to prepare food and all the rest. And I sort of went into what was called medics, which was sort of like first aid. And so you learned a bit about first aid, and then you actually, especially when you're on camps, you were the first line of help if someone injured themselves or was sick. Needless to say, you weren't conducting surgeries. But all of that was good, and I ended up being the sergeant of the medics unit, which should involve going to Papua New Guinea for a training course. And with that came the honour of being the medic to the first 18 football team. So that was highly prestigious, as you can imagine.
And was it a valuable experience in terms of your overall education and preparation for your life?
Look, I'm not sure now. I can't remember it well enough, except that I enjoyed it. I think some of the discipline and just learning to be shouted at by people, which is what sergeants were meant to do on the parade ground. And certainly when you went to Papua New Guinea and they were full-time army regimental sergeant majors giving you a bit of a turn on the parade ground, you learn to adjust to what it's like to have to take orders. I don't mean that's the way you should spend your life, but that's one aspect of life, and you got used to it, and I think that was probably interesting and worthwhile.
Then you go to Melbourne Uni and you do a combined law arts degree. What interested me about that is you lived in Trinity College for those 5 years. I was at Melbourne Uni 10 years ahead of you, and I thought the guys, and they were mainly guys, who were in college had a greater involvement and a greater engagement with college life than they did with university life. Was that an accurate observation that I made back then?
Well, I think there's certainly some real truth to it. I'd probably say heavily engaged in college life and potentially also more opportunity to be engaged in university life because you're living on campus. But it's certainly true that a lot of what you did revolved around the college, and there were intercollegiate activities, sporting activities, which I wasn't involved in, but things like intercollegiate debating, which I was involved in. But because you were living on campus, I probably got a bit more involved in some university things or went to sort of guest lectures or, particular speakers more because it was just easier to do. And some people who I knew from school who were coming in to university for the lectures and then going home, it felt more like a part-time job. Oh, I'm here for the lecture and then I'm off, see you later. Not everyone did that, of course, but living on campus made a difference. And there was that community at college. And I must say the contrast between having a university life in those days and now is just immense because the amount of hours people work part-time when they're students now, and the fact that sometimes they don't have to go to lectures physically, they can do them online. I suspect for a lot of people that university life experience you're talking about and which I enjoyed, especially with the college thing added on, is just not available, I think, sadly, to a lot of students now.
And did you enjoy studying law, Michael?
Yes. Probably at the beginning, I actually enjoyed the arts course more. I was doing history and politics mainly, and I enjoyed that, and it was fine. I probably grew to enjoy it more as time passed. It could be a little bit dependent on the subject. The subjects which involve teaching statutes more than common law, I sometimes found a bit more tedious, and it could also be influenced by the lecturer. And I remember, for example, in company law and trusts, I had Harold Ford, who, apart from being a great legal mind, was also a terrific welcoming lecturer, and hence probably in part because of that, you enjoy those subjects more, and I've enjoyed working in those areas a lot in later life as well.
You mentioned that you debated. I think you started debating at school and kept debating through university and even post-university. Being a formal debater, did it take up a lot of your time? And again, was it beneficial to your life in the law?
It didn't take that much time because probably about half the debates were what were called short preparation debates. You got the topic an hour ahead of when you were speaking, so there'd be an hour preparation, the debate might go for an hour and then it's done. The ones that had longer preparation, the team would meet perhaps about a week before, but it was often as much a social occasion, a chance to catch up with those people, but we'd talk about the topic perhaps for about an hour. So it wasn't a huge time commitment, and it was something you mainly did because you enjoyed it. You enjoyed the competitive side. Frankly, you enjoyed, I think, the performance side, and with a bit of luck, you're doing it with people who are friends, so there's quite a social element. I think it did. There are ways you can pick up these skills apart from debating, needless to say. But I think it did give you some confidence about public speaking in any form, which has, I think, stayed with me to some degree. It did teach you to order your thoughts a bit. It did force you to look for weaknesses in an opposing case, and it did teach you to try and present in an interesting way, which held the audience's attention at least for a little while. People used to say, when I was a very young lawyer and they knew I was a debater, oh, you must go to the bar. But I don't think one should overestimate the relevance of debating to the bar. I mean, it's relevant in terms of the ways I mentioned, but in terms of presentation, I think it's quite different. You know, from what I see of barristers, their presentation to the court is normally more restrained and has to be rather more disciplined than a debater is when they're performing.
You don't come from a legal background, but you finish up doing your articles at one of the biggest firms in Australia, Mallesons. How did that come about?
I think through dumb luck, really.
No, you must have got a pretty good degree.
Well, it was an okay degree, but I knew very little about who one should apply to for articles. That was a bit of a mystery, not coming from a legal background. And in those days, I don't think I was the exception. Not everyone ran around and did a lot of research. I mean, I was hilariously ignorant compared to today's students about the legal market and the firms and the types of firms and the difference in terms of size and the areas in which they practiced, et cetera, et cetera. And one of the benefits of being at college is there are tutors there, and I talked to one of the legal tutors who was in fact a barrister but had previously been a solicitor, and he said, well, here are 20 firms you should apply to. I said, oh, okay. And I think they're mainly, if not exclusively, commercial law firms because that's what he was familiar with. I didn't even question that about applying to a commercial law firm. And one of those was Mallesons. And Mallesons in those days, I think it was the last year they did this because a lot of people didn't like it. And they sent you off for 3-hour sessions with a psychologist down St Kilda Road. And part of it was a sort of a personality test thing, ticking boxes, but also talking to him. And part of it was more of an IQ English comprehension type thing. And I didn't mind that. I mean, I didn't find that an affront to my dignity as some of my colleagues did. And to be honest, I think that probably helped me get the job one way or another. So there we are. They offered me articles and I said yes and got into commercial law.
And did you enjoy your articles?
Yeah, I did. As is still not uncommon, we rotated through 4 different parts of the firm. So that gave you a sense of what was going on and allowed you to meet people. And I quite liked the tasks when I got them that were simple. And I quite liked being asked to deliver something or do the court rounds because you thought you had a fair chance of doing that successfully. Where other things that were more demanding, I wasn't so sure. But you were given some quite, at least for one's level, quite demanding things to work on with some quite senior lawyers. And I must say I enjoyed that as well, even though it was more fraught and you're more anxious about all of that.
You're very aware of what you don't know as an article clerk.
Well, you're not as aware of what you don't know as you should be in one sense, but you're aware of some of it, yes.
You finish your articles and you stay on at Mallesons. Yeah. Obviously, they were pleased to keep you on. But did you ever think of leaving Mallesons? And particularly, of course, I'm thinking of the bar. That never crossed your mind at that stage?
Well, it crossed my mind in the sense that, as I said, people would, casually, not even people who knew you that well, but who knew you debated and had, say, debated in the Victorian state team or whatever, said, oh, you should go to the bar. But it didn't really, at that point, I didn't give that serious consideration. Really, the end of articles, the thing you were thinking about more was, were you going to be kept on? Because that was not guaranteed. It wasn't one of those, of course, we keep everyone on moments. So there was a real question about whether you're going to be kept on, and if you weren't, what were you going to do?
After you've been at Mallesons a few years, something crops up which seems to be semi-regular in your career, Michael, in that you get an itch. And you get the itch to do something different, and so you apply for an in-house job with BHP, and you get the job. Did you go and work for BHP?
Well, I did, but not as their employee in the end. So I did apply, and it was a bit of an itch, and it was caused, it's one of those weird things when you look back at it, because a colleague of mine, a friend of mine who I'd done articles with, went off on secondment to the Corporate Affairs Office here in Victoria, and he left, and I thought, oh, that's, he's off doing something. Perhaps, I should be as well. So I saw this job. I'd done a little bit of work as a very junior lawyer for BHP Petroleum, and so I thought, oh, I'll apply for it. But what happened is I went to tell Mallesons I'd got the job, and one of the young partners there, a guy called Gerald Ryan, took me aside. In fact, he took me across the road, William Street, to a room at the Australian Club to deliver this message and said, this is an incredibly stupid decision you've made and you'll regret it and you really mustn't do it. Gerald was a very direct and forceful man, but usually right about most things, a very clever man as well. And he didn't just leave it at that. He came back and said, well, look, don't leave us and go there. I've arranged for you to do a 6-month secondment there, and then I've arranged for you to do an 18-month or 2-year secondment at Slaughter and May in London, and then you'll come back to us. And that's much better than leaving us and taking up employment at BHP. And I said, golly, I was a bit overwhelmed and very grateful, and that's what I did.
It comes up so often in our talks with people, and I guess in all walks of life, not just the law, the goodness of other people. And I guess Gerald Ryan's one of those people in your life.
Yeah, absolutely. But it's a bit of a recurring theme when I was thinking about my working life for the purpose of this discussion. The number of times you're assisted by someone, and sometimes assisted in a really material way to guide you and suggest a course or provide an opportunity.
So after a few months, 6 months, whatever, with BHP in-house, you're a man in your late 20s, you go off to live in London, which would have been pretty exciting.
It was good, yeah.
And you're working for one of the largest and most prestigious law firms in London. How did it compare with working at Mallesons, which is one of the biggest and most prestigious law firms in Australia?
Look, it was different in the sense that London was, and I imagine still is to some degree, a centre not just of the commercial world but of the legal world, and the extraordinary variety of work that sort of flowed through that firm, and not all sort of England-based either, was a bit of an eye-opener, and some of the things they worked on. So in one sense, especially in those days, may not be as true today, working not in an Australian environment but in a London environment was a difference in terms of variety and perhaps to some degree sometimes the technically demanding nature of the work. But I had expected probably Slaughter and May to be at least as formal, if not more formal than Mallesons. And bear in mind, we are talking 1986. But in fact, it was less formal than the Australian firms. The supervision was a bit more hands-off. The attitude of the partners was more to sort of give you a head and see how you went. And there was less talk about billing targets. In fact, in my 2 years there, I was never told if I had a budget and what it was. You just were expected to do the work, and then at the end of it, it was billed. There was no interim billing as the matter ran. You just billed at the end. They were a firm that was very confident about their place in the legal marketplace, and I think that contributed to this more relaxed attitude about some things. But you did get to work with some very talented lawyers.
Was it difficult to catch up, or being in a common law jurisdiction, was it relatively easy? You sort of understood where the pieces fit together.
Yes, it's a tricky one to answer. It was familiar in many ways, but a little bit, as you mentioned before, about you don't know what you don't know. Things that look familiar weren't always the same, and you need to try and work out when that was the case, and not sure I always did. And the thing that loomed was European law, that is, law of what was not then called, I think, the European Union, which played a part within English law because England was a member of the EU, and that was the area I really didn't properly understand and could have understood better, but we sort of navigated that. I was a bit surprised clients accepted this, especially in my early days, this sort of lawyer just off the boat from Australia turning up on their own to advise them on English law. But I think in retrospect it's because you wore the brand of the firm on your forehead sort of thing, and they were trusting the firm, not you individually.
I wonder if things are still the same. I wonder if the culture is still the same, where these magic circle firms, as they were or probably still are called, have so much cachet that everyone accepts what even a junior lawyer says.
I suspect there is still some of that. What I think has changed, and I only see this from a distance in London, is the way the big American firms have moved in, not just to do a little bit of US law, but to actually set up shop in a serious way in London and practice English law as well. And that, I think, has had some effect on the way the English firms think about themselves. And I saw just recently one of those magic circle firms has merged with a large US firm. So I think that has changed the dynamics a bit in the London market. It'll be interesting to see how that plays out over time.
We better come back to Melbourne, I guess, which you did in 1988 after 2 years of being in London. And soon thereafter, you become an equity partner at Mallesons. Now, I'm assuming prior to that you had not been a salaried partner?
No, I think Some firms did, but most firms, I think larger firms, didn't do that salaried partner thing in those days. If you're a partner, you're an equity partner. Admittedly, you'd start with a smaller share of equity and it would build over time, but they tended not, I think, to have salaried partners.
As a young lawyer in that situation, obviously considered to have significant ability by the partners, do you just sit back and wait and hope someone offers you a partnership, or do you tactfully let someone know that you're available, or how does it work?
Well, the way it worked in those days, I'm sure, is very different from the way it works today. So in those days, certainly I just waited. I didn't tactfully let anyone know. I didn't apply. You just thought, well, we'll see. I think it was helped in my case by the fact Slaughter and May had sort of asked me to stay on, and when I said no, they sort of rang Mallesons to say, well, we've asked him to stay on and he wouldn't, so you should be kind to him, sort of thing, which was nice of them. But no, you just wait. I'm sure there were some perhaps people more confident than me who might have dropped a hint, but I didn't. And frankly, the expectation was, of course, you'd be interested. It wasn't, I'm not saying everyone was, but the expectation was, well, if you're here, of course, you're interested in being a partner. Whereas these days, I'm sure there are many more formal conversations and plans and procedures. And of course, these days, not everyone at those firms is interested in becoming a partner. So it's quite different.
And how did things change when you became a partner?
Well, for a start, no one was supervising your work, whereas as a non-partner lawyer, a partner is supervising your work. It doesn't mean you shouldn't go and talk to others about what you're thinking of doing, etc. But as a formal matter, no one's supervising your work. But you've got responsibility for the work that's being done and for clients and for whether you're running a sort of sound financial ship and for the development of the lawyers who are assigned to you. That doesn't mean they work exclusively for you, but there are lawyers for whom you have responsibility in terms of their career and with whom you'll do quite a bit of work. So all of that suddenly sort of descends on you, and collectively with other partners, you've got a responsibility for sort of setting the standards in the place. That's not the same as being in management. It's just extra responsibilities as a full-time legal practitioner.
Did you enjoy it?
Yeah, I did actually, especially my first few years. It's not like I stopped enjoying it, but there was a combination of some great matters I got to work on. And in those days, and it may still be true, I don't know, but in those days, Mallesons, especially in Melbourne, truly operated as a collegiate partnership. It didn't feel like a company with a hierarchy and executives. Yes, there was a partner in charge and everything, but it was by and large, a happy, supportive place to work. And that's a great thing when you come across it.
Absolutely. Speaking of a partner in charge, you approached that partner in charge at around about this time about setting up a pro bono practice, a formal pro bono practice, as opposed to the ad hoc pro bono work Mallesons had done before. How did that come about?
That was a sort of a curious thing. This was probably 1990 or perhaps 91. Australia's economy wasn't doing that well, and in particular in Victoria, at that time we'd had the collapse of Estate Mortgage and the Pyramid Building Society, and a lot of Victorians had lost savings as a result of those things. So it was all a bit depressed. And around Christmas time, I got a note from, can't remember if it was an article clerk or perhaps a first-year solicitor at the time, but someone who I vaguely knew through debating, saying, why is Mallesons spending money on all these Christmas functions for clients, etc., when it could be doing something useful by doing proper pro bono work for people who need it? And I thought, A, what a very bold thing to say. It would help the fact we knew each other. And B, I thought, well, you've probably got a point. So I sent the note on to Tony Deloisio, who was the chief executive partner, and said, what do you think? And it's, as you say, it wasn't like the firm didn't do pro bono work, but it was quite ad hoc based on particular partners saying we should do the X for some entity to which I'm related in some way or have a connection with. And this was about probably acting for a different sort of person in a more organised, systematic way. And Tony said, yes, we should do something, to his great credit, and set aside for the first year just in the Melbourne office $500,000, which seemed like quite a lot of money in those days. And the young lawyer who'd sent the note to me was in fact someone called Greg Hunt, who went on into the Australian Parliament and in fact was our health minister during COVID. So that note was doubtless to his great credit.
And so what happened? How did you go about setting up a formal pro bono practice within Mallesons?
Well, and look, I should say I don't think Mallesons was unique in moving to establish a more formal pro bono program amongst the larger firms at this time, and some may have had them already. So I don't want to give the impression Mallesons was doing something wonderful and special. But I think the emphasis was on how do we set it up in such a way that all lawyers in the place are happy to do the work, whether they're big supporters of pro bono or not, and how do we do it in a way that we do it to the same standard as all our other work. That is, the point was pro bono is not meant to be a second best thing or which got the second best lawyers or which only got done when people otherwise had spare time. And so there were probably a couple of key rules about it. One was pro bono work, like any other work, was primarily done by the lawyers best suited to do it based on their needed level of seniority and expertise, etc. Now, you'd give some weight to whether a lawyer was keen to do pro bono work, but if the lawyers who were keen to do it didn't have the necessary experience or expertise, we were going to the person with the expertise and experience, whether they were desperate to do pro bono work or not. And the second thing was to give lawyers full financial credit for the work, which is to make them indifferent in one sense to whether it was pro bono or not. So they notionally got to bill that work, and in their personal budgets it showed up as if it had been billed, etc. So as to make it not a case of, oh, bloody pro bono work, I've got to do that. No, I need to say many people were keen to do it, but the point was for those who didn't have that commitment to it, to still make them prepared to step up and do it.
It shows great wisdom, it would seem to me, by the people setting it up at Mallesons and the other firms as well, as you say. Now, that itchiness or restlessness comes into play again with you, maybe mid-90s, and you take a sabbatical. Just the 1 year?
It was 2 years, in fact, yeah.
And you joined Volunteers Abroad.
Yep.
Where did that lead you?
So they are an organisation who seek to place people with particular experience or expertise. It may be technical formal expertise, or it may be simply gained through years of experience in developing countries where there's a job in the developing country that they've not been able to fill with a local person. And there was a job going in Sundown Province in Papua New Guinea called the Provincial Legal Officer, and they hadn't been able to fill that. It's not that there weren't quite a lot of lawyers in PNG, there were, but Sundown Province is relatively remote. It's in the northwest corner of the country on the border with Irian Jaya, so it's a bit out of the way, and the public service pay for a provincial legal officer was not as good as a Papua New Guinea lawyer could earn at a law firm in Port Moresby, for example, so they just weren't able to fill the position. So Australian Volunteers Abroad sent me there. You should say you're not actually a volunteer. The deal is you get paid what a local person would get paid to do the job. So I got a perfectly good, if modest, house, and I think I was paid about $14,000 a year, which was the going
Was
rate.
that enough to live off in PNG?
Yes, yeah, no, it was. It was quite a good salary. It may have been different in Port Moresby, but where I was, it was a good salary, and most people living where I was were not getting anything like that. So that's what I went to do.
What did the job entail as the legal officer for that province?
Yes, so it varied. Some of it was public servants would get in disputes with each other and sue each other for defamation. You tried to sort of sort that out in a way which didn't consume a lot of court time and legal resources and all the rest. There was assistance with local legislation and advising the provincial government on national legislation. There was going to be a copper mine developed in the more remote section of the province, and there was dealing with other public servants who were Indigenous, dealing with the local landowners about the effect of that and what they wanted as a result of that. So a range of things simply to do with the functioning of the provincial government and to some degree the national government in that province.
A bit like your later job as the Australian Government Solicitor?
A little bit on a somewhat more modest scale. And in fact, I was the only lawyer of any sort in the province. There was a magistrates' court there, but the magistrates, although very good at their job, were not strictly lawyers. So it was a bit peculiar being the only lawyer in the province. It was hard to have a legal fight with someone.
And I understand that Britain colonised Papua New Guinea in a different way to how they colonised Australia, particularly in relation to land ownership.
Well, certainly the land ownership was interesting. This is something I learned because I had to get admitted there, and to get admitted, if you had a common law degree, etc., and some experience, you had to still study for and sit exams in 3 subjects: constitutional law, land law, and customary law. And I learned through that when Britain came into PNG, which was in the late 1800s, so about 100 years later than Australia, the Crown said, well, the only land that is going to be owned by the Crown is what was called waste and vacant land, and the land that's clearly occupied by the Indigenous people is not going to come under Crown ownership. It will remain under customary ownership. And the effect of that was, when I was there, going, almost 30 years ago now, well over 90% of the land in PNG was under customary ownership. And you think of the contrast with Australia. So, and someone more knowledgeable than I am could think through, well, what did that mean for the way PNG developed and the stability of that society, etc., that people kept their land and were able to keep using it?
I suspect that's a moot question still.
Yeah.
Lives in the Law is proudly sponsored by City Maps Illustrated. Their recent publication, The Melbourne Map, is a celebration of our wonderful city. This stunning, hand-drawn illustration, which took more than 3 years to create, is available as an art print, jigsaw puzzle and calendar. The perfect acquisition for your home, office or corporate gifting.
So, Michael, after 2 years in PNG, you come back to Mallesons for 4 years, equity partner, commercial practice. You then go to Columbia University in the US, do a master's, but on return, you don't come back to Mallesons, you join the bar. Why did you do that?
Well, I went to Columbia because I'd always had vague thoughts of doing a sort of postgraduate degree of some sort. And I'd also was quite interested in learning a little bit about human rights law and international law, subjects about which I knew very little. So that's what prompted me to go off to Columbia. And I did think it was probably time to leave Mallesons in the sense that I think I was about 45 and I thought either I sort of should commit to spending the rest of my working life here, which wasn't an option I would have hated by any means. It remained a really good place to work. I could very happily have done that. But I also thought if I wanted to do something else, especially something a bit different, perhaps now is the time to jump. And if I left it too much longer, it might have been too late to do that successfully. Hence the decision to jump. I thought it'd be great to have a year studying and it was nice to be in a position to be able to afford to do that because I'm out without a scholarship. It's not that cheap to do that at Columbia. And I wasn't sure what I was going to do after that. I sort of thought perhaps something will turn up in some completely disorganised and hopeful way. Perhaps the Secretary-General of the UN will ring up and say, why don't you come down and work for us? But that didn't happen, you'll be surprised to know. And at the back of my mind was, well, the fallback option would be I'd give the bar a go and see what that was like. So that's what I did. I came back and did the Reader's Course in the second half of 2004 and spent 4 years at the bar.
Did you enjoy the first half of my working life I was a solicitor. Second half I'm a barrister's clerk. The observation I made was most barristers enjoy being barristers more than solicitors enjoy being solicitors. They love life at the bar. Did you like or love life at the bar?
Well, first I'd say I agree with your observation about people generally. That was my impression as well. I probably didn't as much fall into that category, partly because I had really enjoyed my time as a solicitor. There were certainly things I liked about the bar. I liked the work. I liked actually the support that the bar provided in terms of education and other forms of support. And certainly, my colleagues at the bar were helpful and there was a good sort of esprit de corps. But I did miss working in teams, which is certainly what you do at a large law firm when you're working on large matters. And you might say, well, don't you do that at the bar as well? I think, well, sometimes it depends on the matter. But when you're working in teams, the team's made up of individual practitioners who are sole practitioners who you've got together for the team, but it's not like you're all under the one roof as you are with the law firm. So I think it makes that a bit different. And if you've had many years being used to the team thing, it's a change. And also, as a partner at a law firm, you're used to be able to say about some bits of work, well, can you do that? And then we'll review it when you've done it, etc. Whereas as a junior barrister, of course, you're on your own in many ways. And when things got especially busy, you do think, my God, I've got so much to do and even if I work every hour on the day for the next month, I will still be behind. Now, that was me not managing my workload properly, and I think if I'd stayed at the bar, I'd have taken steps to correct that. But at times you thought, dear God, how am I going to get all this done? The other difference was, as a commercial solicitor, a lot of what you do is about sort of putting things in place. We're going to buy something and create a new business. We're going to raise money and do something new. We're going to build something. Whereas at the bar, quite a lot of it is about where something's gone wrong. How do you perhaps fix the thing that's gone wrong, or how do you punish the person on the other side when it's gone wrong? So it's a different, you're working in a slightly different environment in that sense.
It's interesting, but the itch is still there. You had 4 years at the bar, and then you take on the job of being ASIC's Chief Legal Officer. Did they come knocking on your door, or did you read an ad in the paper? How did it occur?
Yeah, I don't think there was an ad as I recall. Perhaps there was, but if I was, I didn't see it. But ASIC was doing a bit of a restructure at that time. The Chief Legal Officer position was, in one sense, a new position. Of course, they'd had a head lawyer before, but this was running a slightly different and expanded in-house legal team, and they were looking to fill a few positions. The ASIC chair, I think, got in, I think it was Corn Ferry, but a search firm to help them, and they sort of knocked on my door. Now, full disclosure, the ASIC chair at the time was Tony Deloisio, who I mentioned a bit earlier, who was Chief Executive Partner at Mallesons once upon a time. So it wasn't like I was completely unknown to the ASIC chair, but I went through a process with Corn Ferry, and lo and behold, they said, well, you might be suitable, and I ended up with the job.
I mean, we all know what ASIC is, what basically the corporate regulator. Is that an accurate description, or is it a bit more nuanced than that?
No, it's accurate, but ASIC's role has grown way beyond that, and you'll hear sometimes commentary about has it grown too much and does it do too many things, etc. But it certainly regulates corporate behaviour in directors and company insolvency, but it also regulates the financial markets like the stock exchange and financial advisors and investment schemes and things like fundraising and takeovers, and also the provision of some types of credit. So its remit these days in the commercial world is huge, really, way beyond if you think back to the Corporate Affairs Office in the various states, which was much more just focused on company behaviour.
I think it's fair to say it did have the reputation, and it may still, although I'm not current, of being a toothless tiger. Was that fair, and has it changed?
It was said about ASIC and still is from time to time, and frankly I suspect some people will say that at intervals forever. I do think regulators are always capable of doing a better job, for sure, and sometimes they have periods when they don't do the job as well as they could. But I also think it's true that they will rarely, if ever, please a lot of the commentariat. And it's a difficult job, and ASIC is told in its legislation and sometimes by treasurers that it must sort of promote a vibrant economy and let people get on with doing great commercial things, and it's also told it mustn't allow a whole range of things to happen and crack down. And it's a matter of balancing those things. I'm sure there were times when ASIC could have been more aggressive in doing things about particular types of misbehaviour. I don't doubt that. But I also think sometimes it was a bit of a whipping boy without the best reasons.
When you came in as Chief Legal Officer, I think it was during the James Hardie case?
The James Hardie case had started the trial. That was a case that went to trial and then Court of Appeal in the High Court. And I think when I turned up, the trial was underway or was just finished
in the federal court?
No, the trial was in the New South Wales Supreme Court.
And what was it about?
Well, James Hardie, I think probably still a well-known company, but a large listed company, and part of what it had done in the past was produce asbestos products, and that had given rise to a range of injury and damage to a whole range of people, and it was facing liabilities in relation to that, and I think it decided it would like to free the ongoing company from the risk of those anticipated liabilities. So it set up a sort of compensation fund and tried to make sure the liabilities belonged in a loose sense to that fund, and it gave them, I think, about $300 million. That number might be wrong, and say, well, there you are. And it made an announcement at the stock exchange saying we've done all this and the funding it's got is enough to meet all anticipated legal claims, and we, the ongoing company, are off the hook, effectively. And that proved not to be true. It wasn't enough money, and in the court case that ASIC brought against the directors for approving what they said was that misleading announcement to the exchange, it was said, A, it wasn't enough money, and B, the directors ought to have known that at the time. And I think that ended up being accepted in the courts.
What remedy was ASIC seeking? Money from the directors?
No, that was... There was a whole range of other controversy went on about that, including a commission of inquiry in New South Wales, and there was government legislation, and more money, I think I'm right in saying, was ultimately provided. ASIC's action was simply about that behaviour of the directors, alleged behaviour, in authorising an announcement which gave that false impression to the market and indirectly to claimants that there was a pot of money set aside which would be adequate when it wasn't.
And you you won at first instance,
Yep.
lost on appeal.
Yeah, we lost on appeal, and the reason for losing on appeal had ramifications potentially which went way beyond the particular case, because the Court of Appeal said, and it was a bit of an absolute slap in the face for ASIC the way it lost too, because the Court of Appeal said, well, ASIC hasn't proved that the directors did approve that announcement, and what's more, ASIC had an obligation of fairness in running the trial, and it breached that obligation by not calling a witness who may have had relevant evidence to give. And because it breached that obligation, it, I think in the words of the Court of Appeal, reduced the cogency of ASIC's case. That is, it caused the Court of Appeal to say, I'm going to discount the rest of the evidence that ASIC has produced and discount it to a degree that we're going to find you ASIC, have not proved the directors approved that announcement. So it was a bad loss at that point in the actual case, but it also suggested ASIC had been a bit, underhand, and the consequences were the rest of your evidence could get marked down with consequences for the outcome of the case.
And so what did the High Court say?
So going to the High Court was really important for ASIC, for all the other regulators who were thinking, my God, does that apply to us, etc. And I should say ASIC accepted that it was expected to conduct litigation fairly. The High Court said, well, of course you are. You may have an obligation of fairness, but we don't need to answer that. But certainly there's an expectation. But it said this witness that the Court of Appeal was talking about, there isn't reason to think that his evidence would have in fact been favourable to the defendants in the case. So it was not a breach of any obligation of fairness for you not to call them. And more importantly, if it had been a breach, you don't remedy it by marking down the cogency of the rest of the evidence. You remedy it by saying to ASIC, you must call that witness or I'm going to stay the proceedings until you do, not we're going to just discount the rest of your evidence. So the High Court said, so no unfairness, and even if there had been, it wouldn't be remedied in the way the Court of Appeal had, and we're going to find the directors did approve that announcement and hence had contravened their directors' duties in various ways, and it was a happy outcome, and it took the stain away from ASIC of being seen to have acted unfairly and improperly, and that was really important at the time. I remember when the High Court judgment came through one morning at ASIC, it really resonated with, well, thank God we're not sort of sitting under that dark cloud.
Michael, in the Storm Financial case, when you were at ASIC, you did something different. You actually were seeking damages on behalf of people, which is not a typical thing for a regulator to do.
No.
Why did you take those steps?
Well, that was something driven by the then chair of ASIC. But Storm Financial had run, and that was the name of a company up in Queensland, which had run a major investment scheme or series of investment schemes for some years, which involved ordinary investors going into a scheme under which they borrowed money to invest in the stock market, in particular funds which Storm had set up. And quite often the money was borrowed on the security of their home, the home they were retired in or hoping to retire in the not too distant future, and then there might be further money borrowed on the investments they'd already made in the stock market. So it was quite a heavily geared arrangement, and it had run quite successfully for some years. Storm Financial would have said they only offered it to people for whom it was a suitable investment, and I think ASIC would have said there weren't many people who knocked on Storm's door for whom they didn't find it to be a suitable investment. And the global financial crisis came along and the value of shares plummeted, which means that the loans that had been taken out to buy the investments in the stock market weren't properly supported, and they were often called on and people couldn't afford to repay them, especially because the things they bought with the loans were worth a lot less than they had been. And it was sort of a major disaster for the people who'd invested in Storm, and there were losses. My recollection is of 800 million plus, and ASIC certainly doesn't always, by any means, in a minority of cases, pursues compensation. It will look at seeking to take proceedings against people who've misbehaved, but compensation will often leave for private firms and private remedies. But on this occasion, ASIC, I think because partly of the size of the disaster that had unfolded and the many, many people who were affected, decided it would endeavour to do something to recover the money. And the issue was you couldn't recover it from Storm Financial because it had gone into liquidation or some form of insolvency. And although ASIC did take regulatory proceedings against principal directors of Storm, and they were people of some means, but not they didn't have the means to compensate people for hundreds of millions of dollars. So what ASIC ended up looking at was there were banks sort of tied to the scheme who'd loaned the money. There was quite a complex argument about the way those banks were involved in an unregistered managed investment scheme, which led to potential liability under the Corporations Act. And that was Commonwealth Bank, Bank of Queensland and Macquarie Bank. And there were proceedings brought against them which had many ups and downs. But in the end, ASIC settled with Commonwealth Bank and Bank of Queensland for, especially in the case of Commonwealth Bank, who were, I think in some ways quite responsible about that in the end, for quite large sums of money.
Sorry, do you mean they acted responsibly or they were held responsible?
They, I think, acted responsibly in the end in terms of the settlement. Not everyone would agree with that, but I think they thought about their role as a corporate citizen. And then there was a class action brought separately against some of them, including Macquarie, and Macquarie settled with the class action people, which effectively put an end to our proceedings, but money was obtained from Macquarie as well. And in the end, I think the amount recovered was probably slightly over half of what had been lost. I don't mean that's a terrific outcome, but it was actually, ASIC was involved in helping extract quite a lot of money from people who weren't obviously immediately liable for the damages, and it did something to make good the losses of the investors.
I've got an itch here you can scratch for me, Michael. If you'd lost that case, would ASIC have to have paid the cost of the Commonwealth Bank and Bank of Queensland?
Yep.
So there's a big risk there for
Yeah.
ASIC as a Commonwealth government agency.
That's right. I mean, ASIC was funded to take on some big cases and both to fund its own costs in running them and to then pay the costs on the other side. So it was in a position to do it. But yes, it was a big commitment from it in terms of staff, resources, money, and the risk of paying the other side's costs. And as always with ASIC and other regulators in the public eye, if we'd lost, it would be, what's ASIC done? It's brought this hopeless case and it's lost and, silly old ASIC. Whereas in fact it was, I think, a good outcome. And in fact, there's at least one academic article has been written about whether there's merit in regulators doing more of that and whether they do it more efficiently and there's more money for the people who've lost than if a private operator does it.
Interesting one, that last point.
Yeah.
Where there's more money for the people who've lost.
Yes.
William and Lonsdale is brought to you by Green's List, one of the leading multidisciplinary barristers lists in Australia. Green's List believe in promoting conversation around the ideas and issues that shape not only our legal system but our wider community.
Michael, after 8 years at ASIC, you become the Australian Government Solicitor. Did they approach you and because you obviously got a very good track record working in a government environment as the Chief Legal Officer at ASIC. Did they then come to you and said, we'd like you to be the Australian Government Solicitor?
Not quite as welcomingly as that, but that was the occasion I did see the ad in the paper and I'd had a bit to do with AGS at ASIC and thought, I'd be quite interested in that. AGS are an impressive outfit. But I also thought, because again, there was a sort of a search firm, I thought, well, if they look around, they'll know, I exist in the Commonwealth government space, along with a number of other potentially suitable applicants. So if they think I might even remotely be suitable, they'll come knocking. So I didn't apply, I waited. And they did approach me and I said, sure. No, there was then an, interview process and all the rest, which I went through and I was lucky enough to get the job.
So, we all know the AGS and in my mind it's the government solicitor. Is it as simple as that? Is it just like a large firm and its clients are the various ministries and departments and agencies of the Commonwealth Government?
Certainly there its principal clients, like 90+%. It does occasionally act for a state government body. There's a special procedure for getting approval for that. An example is if a state auditor general is having a fight with some other bit of the state government and it doesn't want to use the state solicitor for perhaps obvious reasons, it might come to us. Or sometimes we act for multi-government bodies like AHPRA, which is the Health Practitioner Regulatory Agency. That's not strictly a Commonwealth government body. But yes, look, the vast majority of our clients are those people. Are we like a large private law firm? I still say we, to some degree. And to some degree is AGS has to compete for most of its work. There is some work which is tied to it. So constitutional law work, national security law work. There are some other examples. AGS must be used by the Commonwealth, but otherwise the Commonwealth's free to use its own in-house lawyers in a particular department or private firms. So it competes for its work, and it's also not budget funded. Its funding, its ability to pay rent and salaries comes from billing clients for its work and collecting on those bills.
100% of it? There's
Yes.
no funding from the government?
No.
Except they pay their fees.
Exactly. So in that sense, that competition and having to bill and being dependent on client satisfaction for your work, it is quite like a private firm. It isn't in this sense that although these departments and agencies you referred to, our clients, have their own in-house lawyers sitting normally within those departments and agencies, and some of them have a lot of them, AGS is also a little like an in-house lawyer in that its overwhelming client is its employer, the Commonwealth. It's just that it's like an in-house lawyer slightly removed because it's not sitting in the Department of Home Affairs, or it's not sitting in ASIC, or it's not sitting in the tax office. It's separate and has a little bit of distance in that sense. But it's also, and this was part of a selling point, I think, for AGS, it's also inside the tent, the government tent, and I think understands the way the government operates and government sensitivities, etc., better normally, I'd say, than private firms. And because it's a government lawyer, those, I think, heightened ethical and other obligations on government lawyers apply to it.
So it's like a firm, and some firms cover all areas of the law, or most areas of the law. But as your principal client is the Australian government, is it mainly administrative law and government law you do? Or might you do some crime, might you do some personal injuries, etc.?
It's certainly broader than admin and constitutional, although that is a public law, including that is undoubtedly a very important part of what we do. But if you look at the dispute resolution practice, which deals with all the occasions and the various weird reasons for which the Commonwealth might end up getting sued, and also when it acts for a range of government agencies when it's the plaintiff, such as the tax office looking to collect tax, or ASIC looking to enforce the law, or the ACCC or AUSTRAC about money laundering. Now, I don't mean we act for those people in all their cases, but and I keep saying we again, AGS does act for those people in many of their cases. So there's a whole range of things it does in that dispute resolution practice, including personal injury. And I do think it probably has one of the larger DR practices in the country, and certainly I'd be surprised if there's a more interesting practice in terms of the variety and significance of the work. Then there's the public law advisory practice, which is about developing legislative schemes and constitutional law and what's required to implement policy. And there's a commercial practice, which is helping the government with some of its projects, such as the development of Western Sydney Airport. So although it certainly doesn't practice in everything, the breadth of its practice really is, I think, surprising.
Part of the practice is litigation, and obviously as representing the government, you're meant to be a model litigant.
Yep.
Is that difficult to be held to? Are you held to a higher standard than the rest of us in litigation?
Yes.
And is it difficult?
I think the government is, and I think the government should be. I did wonder when some of the changes to civil litigation, legislative changes came through, over 10 years ago, which put standards on ordinary litigants about the way they have to conduct litigation, whether they were being raised to a level that they were almost being asked to be like model litigants. But even if you could make a case just simply when you read the legislation that it was a bit like that, it's not true in practice, and government is held to a higher standard. And AGS lawyers, I think, were very aware of that by and large, not always perfectly, but by and large were aware of the need for a high standard. And when you think about some of the things government does or is seeking to do, such as detain asylum seekers, for example, or question whether people need to repay benefits they say have been wrongly paid for them, it all makes sense that the government is held, when it's interacting with its citizens, to a high standard. What AGS, I did notice, is people will allege a breach of the model litigant obligation quite frequently. And part of my job was I would look at, normally after someone else had looked at it, every allegation of breach of the model litigant obligation. And I do think some of them, the people making them may not have seen it like this, but some of them were tactical or just an easy thing to say as a throwaway line. But there were occasions when there had been a breach and steps needed to be taken to apologise for it and rectify it.
But did it make it harder to prosecute litigation?
I don't think it does in the scheme of things. I often think if you have a reputation in litigation for setting a very high standard for yourself, in the longer run, it might benefit you, frankly, rather than make your life harder. I think trust the courts might place in you when you say something to them might be greater if you've got a track record of behaving very well in front of the courts, for example.
What about politics? Is the AGS affect, when its main client is a political body, does it have an impact upon the AGS and how it does its work?
I don't think it does to a large degree, partly because our instructors on the vast majority of occasions are other public servants, so that not always, but vast majority. And yes, they might be hearing from their ministers, but the AGS lawyers would be one removed from the minister's office ringing up in a fury about something, and our poor clients would be dealing with that more than we would. What you did notice is sometimes when there was, say, a change of Attorney General, what they were interested in keeping across might vary, or their approach to things like when something should settle could vary, all within the scheme of what's acceptable legally, but just their interests and their views could affect those things. But the number of matters an attorney would be personally interested in is a relatively small part of the picture. Now, obviously, with the government also, what it does in terms of changing policy or statute can affect the sort of work AGS is doing. It can lead into that change of policy or statute has produced greater litigation in a particular area, so we'll be involved in it. But that's not politics affecting our work in that direct sense, I think you're meaning.
If you want to do constitutional law, you have said you should be working for the AGS. Does it therefore attract a lot of the best and the brightest young lawyers?
Well, I think it does, but you might say, well, he would say that, wouldn't he? But I think it's true, and especially if you're interested in public law, even if you're not, if your interest is broader than that, I think what it offers in terms of the range of things you can work on, their legal interest and their interest sometimes, not always, in terms of national significance, does mean it attracts people for whom they think, yeah, that's an exciting thing to be working on. But in terms of public law, it's undoubtedly true that some people, even people who I think are planning to go to the bar, I think 2 or 3 years at AGS working in the public law space will be a good foundation for a career at the bar in public law, for example.
And do you think it gives those people and yourself a feeling that I've made a contribution and a significant contribution towards the life of the nation?
Yes, I don't want to overdo that or make it grander than it is. And I think sometimes you just think, well, in small ways I've made a contribution. But every now and again, I think, for example, AGS were the solicitors assisting the Royal Commission into Financial Services that Kenneth Hayne ran. And I think the lawyers who worked on that think, well, we've done something quite significant. Or the commercial lawyers who helped get Western Sydney Airport up have probably walked away thinking, well, that's a major piece of the country's infrastructure that we've contributed to. Or the lawyers who were in the High Court when MPs were being asked about their foreign citizenship probably thought, well, we've been working on something that has been dominating the nation's attention for a time. So there are things like that. But I don't think the lawyers walk around every day thinking, I'm helping the country.
No. But in certain matters, and maybe a lot of matters, there is a sense of making a contribution and a worthwhile contribution.
Yes, I think you've got to be careful not to blow that up too much, but I think there can be a sense of that.
So, and what about Royal Commissions? Where does the AGS sit in relation to Commonwealth Royal Commissions?
We normally have a role, but what role depends. So sometimes it's the solicitor assisting the Royal Commission and sometimes it's the solicitor representing the Commonwealth before the Royal Commission. And it tends, and this is not AGS's decision, this is the Attorney General's Department appoints or helps appoint lawyers and decides who's going to assist the Commission and who's going to represent the Commonwealth. But I think it largely depends on whether the Commonwealth is, by and large, the subject of the Royal Commission or someone else is. If it's the subject of the Royal Commission, I think it's often thought it may not be appropriate for the Commonwealth's main lawyers to be assisting the Royal Commission, not least because they've probably done some work for the Commonwealth in the past on the area being looked into. So, as I said, on the Financial Services Royal Commission, we were the solicitors assisting the Royal Commission, but if you look at the Robodebt Royal Commission, we were the solicitors representing the Commonwealth in front of the Commission.
And if you're representing the Commonwealth, who's acting on behalf of the Commission, the Royal Commissioner?
So they normally go to a private firm, and I'm sure a range of private firms could do it, but there are a couple that have probably now done 1 or 2 Royal Commissions relatively recently because we've had quite a lot of Royal Commissions in the last 5 or 10 years, more than would be normal. So there are some with, some considerable experience of doing that now.
And they would be the big national commercial firms?
By and large, I think I'm right in recalling Gilbert and Tobin have done a couple. Mallesons, King and Wood Mallesons have certainly done one. there'd be others.
They need to have significant resources.
Yes.
Michael, that brings us up, I think, to last year when you finished your time as the AGS. What we haven't touched on so far, which has been a significant part of your life in the law, is the Fitzroy Legal Service. Very different to the heights of the AGS and Royal Commissions. I think maybe the first legal service in Victoria, of such legal service in Victoria.
I think it might be the first non-Aboriginal community legal service in the country, I think, set up in 1972.
How did it cross your path or you cross its path, and how long were you involved with it?
And I should say, I'll talk about that in a minute, but there's nothing especially remarkable in my involvement, save perhaps for its longevity. And Fitzroy ran, and still does, where it runs a nighttime service for clients, often walk-in clients, which is largely run off the strength of a volunteer lawyer workforce who come along at night, although is normally assisted by one sort of overseeing full-time Fitzroy Legal Service lawyer. And then during the day they do a host of other, sometimes strategic litigation, policy reform, and assist other people, with their paid staff. So I started volunteering there on a Monday night in 1982 when I was an article clerk, and I finished doing that about 2010. Now, needless to say, I wasn't doing it when I was living overseas, and later in my career, I didn't get there every Monday night either, or I got there a bit late, frankly, because of other things. But I did do that for quite a long time. When I first started doing that as not even as a lawyer, as an article clerk, so I wasn't giving direct advice to clients, everyone will be pleased to know. And then as a raw lawyer, I did it with a lot of assistance from more senior lawyers who were volunteering, people like Brian Wright, who taught me a lot about advising individuals. You can see a lot of individual clients at Mallesons, and in areas of law that I didn't necessarily see a lot of at Mallesons. So I learned a lot from other senior lawyers there, and I also learned a bit from our clients, frankly, about what was going on in the real non-corporate world. And you also then, there are a lot of friendships created among that Monday night crowd, which kept drawing you back, I think, as well. So it was very worthwhile for me. Hopefully it was worthwhile for some of the clients as well. But in a way, I always thought the real heroes there were the full-time staff who were working there on a salary which was a lot lower than they deserved. They weren't going back, as I was, to a job where I was quite well paid.
Were there any skills you learned there which you took back to that well-paid job?
There were some areas of law I came across which then from time to time cropped up and were relevant back at the well-paid job. And I think you learned a bit about dealing with individuals under stress. Not everyone was under stress, but quite a lot of people were for various reasons. And I think you did learn a little bit about how to deal with individuals under stress more effectively than I otherwise would have.
Can you tell us what those skills would have been?
Well, partly I think with those people it was not sort of jumping in with answers too soon or cutting them off, but initially letting people talk out what they wanted to say at reasonable length. And then after they'd had a first go at that, perhaps circling back to say, tell me a bit more about the thing I'm not understanding, but not giving them initially an opportunity to say pretty much everything they wanted to say, even if you're sitting there thinking, I'm not sure some of this is completely relevant. And your assessment of that wasn't always right, you found out when you got to the end of the story.
Would it be fair to say, be it the Fitzroy Legal Service, Mallesons or the Australian Government Solicitor, it's always about people?
I think it is true. Even when you're acting for sort of agencies, departments, big corporations, the people making decisions there and the people feeling the ramifications of what's going on are human beings.
Michael, you've had a long and varied life in the law, very interesting, which has interested us this morning, thank you. And it's not over yet. You've got a future. I won't ask you about that.
Thank God, yes, I did.
Is there anything in particular which gives you greater satisfaction, possibly in PNG or ASIC, the AGS, Fitzroy Legal Service?
Look, that's a bit hard to say. I think there were some years at Mallesons which were particularly enjoyable, great work, great relationships. The ASIC experience, although it had its more fraught moments, also great work and achieved some worthwhile things. Enjoyed AGS. I can think of, one or two times at the bar, one acting for an individual, coming back to what we were talking about before, who was an asylum seeker, been in the country a long time, raised children here, but then was about to be deported, and we went through a couple of levels at court about that. I was just acting for him. They weren't solicitors, and we lost, in fact, although I almost thought we were going to win at the last stage in the court, and so did the other side, but we didn't. But then Asylum Seeker Resource Centre wrote a letter asking the minister, I think then Amanda Vanstone, to exercise her discretion which she did. And I do remember the day he came in to see me at the bar to say this had happened. And that's probably one of the greatest times I felt greatest pleasure in a legal outcome, I've got to say, of all of them. So,
would you change anything, looking back?
Probably change 50 things. Who knows what they are, but doubtless I'd change many.
And I always ask people in your position, what advice would you give to young people? Someone who's in Trinity College at the moment like you were, or is living at home with their mum and dad like I did and getting into university every day, or an article clerk, a young lawyer. What would you say to them about the practice of the law?
Well, I'd first say if you are going to, well, you might first decide, I'm going to see what this is like, and who knows how you'll find it. But if you're going to stay, I think you should only stay because you enjoy the practice of the law. And if you find you don't enjoy it, and that won't be a remarkable thing, and it won't mark you out as some person who hasn't succeeded. It just isn't for you, and it's not for everyone. And if you're not enjoying it, I'd say leave. Don't sit it out for 10 years or whatever it might be. Recognise, as I think most young people will today, there are many different ways of practising the law, a huge number of different ways one can have a career in the law. And what's more, these days you probably won't have one career in the law. You'll have quite possibly, certainly careers at a range of different employers, workplaces, but possibly also practising law in a variety of different ways. And if that's what appeals to you, embrace that, and it might make the whole thing more interesting. And you may, if you move around a little bit, find the way of practising law which you find most enjoyable. And perhaps I'd also say, you don't have to be particularly brilliant or frankly brilliant at all to have a successful and enjoyable career in the law and to be a good lawyer. I think you do need to be conscientious and to be prepared at times to work hard. I don't mean 20 hours a day, but to work hard. And I suspect in most areas of the law you need an eye for detail. That won't be true of everyone, but I think it's true. But you don't need to be some genius. Skills with people, in the way we were discussing before, can be as important or more important than legal brilliance.
Michael, thank you for telling us about your such an interesting life in the law, and may your future life in the law be equally as interesting for you.
All right. Thank you, Michael.
Show notes from today's episode can be found at greenslist.com.au/podcast. There you'll find links to things we've talked about in this episode, a transcript of the show, and some wonderful photos of our guests. If you're enjoying Lives in the Law, please tell your networks, subscribe, rate and review the show. Your host is former lawyer and Greens List clerk Michael Green. Our show is produced and edited by me, Catherine Green, mixed and mastered by Windmill Audio, and recorded by Alex McFarlane, who also wrote and performed all the music for the series. We're coming to you from the iconic Owen Dixon Chambers on the corner of William and Lonsdale Streets in our beautiful city of Melbourne. We acknowledge the Wurundjeri people of the Kulin Nation as the traditional custodians of this land and pay our respect to their elders past and present. There is no doubt that conversations about justice have been taking place on this land for thousands of years, and we are privileged to continue that discussion here today.